So this is my brief. I've been asked to look at the changing health and safety landscape and specifically how this relates to the Charter. And so what I've done is I've picked up each of the 10 commitments and I've related that back to the legislation so you can see how practically the Charter is actually working for you. And so we'll start with the first one, which is leadership. For me, I don't know about the Australian experience, but I think the changes to the Act around leadership are probably the most important for you to understand. And I'm seeing now from a number of boards and senior managers around Canterbury that they're really, and around New Zealand, in fact, that they're really starting to understand that leadership is the key to health and safety. And so we go to this section here, officers, who are they? And so it's obvious that all directors of companies are officers. And there's no real change from the current legislation in that respect. But we go on to talk about those in a partnership. So when you partner within a partnership, there's also the limited partnership, a general partner, and then body corporates. So there's no real surprises, I think, in who an officer is in the general sense. But it's when we get to the next part, which is who else may be included, I think we start to see some real concern. Now, we have a slightly different model from the Australians. The Australians have a participation type analysis of who could be a leader. In New Zealand, what we're looking at is, first of all, the CEO clearly is an officer, but then some senior advisors. Now, in Australia, there's discussion that that's going to include legal counsel, COOs, and CFOs in a larger organisation. In New Zealand, it's about who actually makes the decision as opposed to advising on the decision. So if you're, for example, an HR manager or even a health and safety manager who's simply advising to a senior board, I don't think that you're going to be an officer under the new legislation. But if you are in a CFO role or even a COO role, where you are making some significant decisions on behalf of the company, and I don't just mean parts of the company, but the whole of the company, then arguably you will be an officer under the new legislation. How this relates to a smaller company, we're not quite sure yet, but in a smaller company, of course, you might have one or two people up the top who are running it, whether it's a general manager and an office manager. And again, if you're making those decisions, not just advising of them about the whole of the organisation, arguably you could be brought in. So, in terms of this question here, our leaders demonstrate a visible commitment to health and safety. Not only do you have to do that because of your commitments under the Charter, but the Act's going to make you do that. And of course, if you don't, there are some significant penalties. So the second commitment is one of engagement and consulting. I think this is the area where arguably the backbenchers in the National Party are getting a little bit excited about SMEs. There's a lot of prescription in the Act, and it takes up a huge part of the Act for New Zealand and also Australia in terms of what you must do to engage with others within the organisation. And for me, it's under three parts. One is the engagement, one is the worker representation, and the other one is the worker participation. And so in terms of that, what we're seeing is that there is an obligation for you to engage with your workers on health and safety and in a meaningful way. From a practical perspective, when I talk to clients and I say, well, who are your health and safety reps? And they say, oh, no one wants to be a health and safety rep. And I say, well, what do you do to encourage them to do that, to take on that role? It's an extra duty. Is it part of their job description that that this is their role? Do you pay them more? Do you give them extra recognition? Do you actually tell them what the role's about and so on, and their indemnity under the new Act, of course? So it's about understanding with engagement with workers that when there's a health and safety decision to be made, workers should be involved. I mean, I think for most organisations, you really get to understand where the health and safety risks are when you talk to those guys who are actually at the coalface, who are out there actually doing the job. The second part is the worker participation practices. You have to have this reasonable opportunity to allow people to participate in health and safety decision making. And in part, what this is about is it's actually allowing them time. And I think that's very important. The third part is obviously allowing the health and safety representatives to be elected and to encourage that, I think, in your organisation. Recognising, of course, that they're going to have some significant powers. They already have some powers under the current Act, but under the new Act, they're going to be quite significant. From ceasing work to being involved with investigations, to requiring documentation from you. These people will have certain powers to really, as a PCBU, make you do your job. And lastly, of course, health and safety committees. And for me, I think a health and safety committee from a practical perspective must be one where you involve people from the top down. I mean, a CEO should, in most cases, be involved in the Health and Safety Committee. That's just my view. I think directors in some way should have some involvement. Contractors to the organisation should also have some involvement. If you've got different branches or you've got different functions within the organisation, try to get someone from each function to be involved. Then you get a full range of what are the health and safety issues for your organisation. So in terms of the second commitment, engagement and consultation, I think this is going to see a bit of amendment when we see the Select Committee come back on the 24th of July, primarily around SMEs and certain other aspects, farmers for example, but otherwise it's going to involve, I think, many organisations ensuring that they actually do engage with their staff. The third commitment is critical risks. It's interesting, this is more of a risk-based act than it is a hazard-based act. If you look at the way it's drafted under the old Act, they mention the word risk twice in 2 minor sections. Here, this is very much risk-based, and they define risk and they define hazard. Risk to me, or the difference between risk and hazard is this. A hazard is a piece of machinery which is sitting on your floor. The risk is when you put the human interface with that piece of machinery that could potentially harm them. So think about it that way, and this is the way that this Act, I think, is based. It's looking at the risks involved in the workplace and how you eliminate or minimise. Now, of course, isolation is missing from the new Act, and I think where isolation fits in is probably now it's part of minimisation. So currently we have the steps of eliminate, isolate, minimise. The new Act is simply straight from elimination to isolation. To minimisation, and isolation forms part of that minimisation. So an example would be if you have a piece of machinery that's dangerous. To eliminate is to remove the machinery from your workplace. Now sometimes you can't do that, and quite often you probably can't. To isolate under the current Act would be to put guarding on it and to try and ensure it's safe in that respect. To minimise under both Acts will be to train people, to supervise them, and to ensure that you have experienced people on that piece of machinery. So I think under the new Act, when you're looking at minimisation, isolation, it'll be about guarding and training and supervising people on dangerous tasks. So in terms of critical risks, I think this is very much a risk-based Act, and it's something that we have to bring our mind to, that we're looking at that human interface with hazards within the organisation. Fourth, site safety risks. We implement and monitor site safety plans. It's very important to have these plans and to ensure that they're updated, but that they're fit for purpose as well. To have a generic plan off the internet's not going to work if it doesn't actually fit the workplace in which you're actually operating. And so what the Act talks about here is that regulations will deal with this. And so what we're going to see, unlike the current regulations, the 95 regulations, which really sit to the side of the Act and no one really takes much notice of, the regulations for this legislation will be very comprehensive, and I think what they're going to do is they're going to expand upon what is very simply drafted legislation, and it's going to expand upon it and give you an understanding of what you're required to do. And specifically, I think with regulations, there'll be quite significant regulations drafted. The government intends to bring the regulations out at the same time as the Act. Whether they get there, we're not too sure, but it'd be good if they did, because it will allow you a real understanding of what you're required to do. And part of that is site safety specific management plans. And so I'm not certain what they're going to do yet about that, but I think there'll be some practical aspects within the regulations that will help you as to how you deal with these plans. Number 5, reporting. So you must have a robust, proactive and accurate health and safety reporting. This is where Worksafe shuts their ears. What I think in reporting is really important is that, when you have something to report, it's that verbal or written document you give to Worksafe that forms the first part of the evidence they gain against you. So I think you've got to be very careful about how you report. And I like to think that you do this firstly through centralising it within your organisation and have that person trained to be able to report properly. And also, and it's not giving a plug for lawyers, but go to your lawyers if you need to at an early stage, because you can find that in reporting at that early stage, you incriminate yourself. or your company. So you've got to be very careful about how you report. The interesting thing is going to be, well, what do we report? Now, under the current Act, serious harm or an accident, and typically people only really report on serious harm, because if we were to report on every accident the way it's defined, WorkSafe would be swamped. This Act, in terms of how the reporting obligations have been drafted, is going to, I think, widen the types of reporting you should do. The first one's obvious. Under the notifiable event, you're going to have injury or illness. Now, that's an obvious one, similar to the current legislation. But it's this notifiable incident that's interesting. And what it states is that where you expose a person to serious harm that's immediate or imminent, you must report that. Now, if you think about it, there can be so many instances which expose you to immediate or imminent risk. When do you draw the line? And I think this is where there can be some understanding with WorkSafe as to actually when you should be reporting. One example, I think, is the way that the rugby unions are doing this. New Zealand Rugby Football Union, Canterbury Rugby Football Union. I mean, if you were to go play a game at that senior level, every time a 120 kg prop bears down on you, that is an immediate and imminent risk. So do I have to report that? Well, clearly not. Every game you're going to find injuries, and significant injuries. I mean, to which level do I report? And I think those organisations are now coming to an understanding as to when they report. And that's something I think that you might look at, as to how do I actually report, get it centralised, get it done properly, but when I report. And again, immediately, verbally, and within 48 hours in writing. So your time frames are truncated somewhat. Commitment 6, training. All our workers receive health and safety training. I mean, this is, I think, vital because it starts with education at the very beginning. If you get it right from the beginning with training, you hopefully don't have to have too many issues down the track. And so in looking through the Act, I've just picked up these 6 prime areas which really enforce how much training is important. The first one, of course, is the purpose of the Act. It says there the promotion and provision of advice, information, education and training. So the core purpose of the Act is to include training of health and safety. The second part is the primary duty under the Act, that's clause 30, where one of the primary duties of a PCBU is to provide information, training, instruction or supervision. So again, your duty to provide training. If you don't provide training, you're in breach of the Act and subject to penalties. The third one is engagement, where you must ensure that there is information and training provided to your workers. Remember, of course, workers is employees, contractors, subcontractors, volunteers and so on. So it's quite a wide range of people you must provide that information to. The fourth one is representation. That's, of course, training for health and safety representatives. And I know in Canterbury, for example, the Chamber does some good training, and I know a number of the unions provide training. I'm not certain that we've got enough training facilities out there at the moment, and something we probably need to work on. And what WorkSafe's doing today is excellent for training in itself. Then, of course, there's a clause under the Act that a court can actually enforce upon you a training order. So it's a little known section that people haven't really talked about, but I mean, how dare the court come in and step into my shoes as a PCBU and tell me what to do? Well, the Act is saying they can do that, and they can enforce upon you to train your workers. So not only do you get stung with a penalty over here, but you're actually told how to run your business in terms of training. So be prepared for that. And lastly, WorkSafe, of course, they promote and support research, education and training, and they do it very well. Racing along, how's my time going? Commitment 7? Good. 3 more commitments, we'll get there. So number 7 is site induction. So everybody must be made aware of hazards so they can look after themselves and keep others safe. It's really important under the current Act, but equally important under the new Act. We get so many questions from clients saying to us, but I don't go to that site, so how can I induct people on it? Or, he's a worker from another site, why should I induct him onto my site? But what we are seeing with a number of our clients is they are inducting not just their own staff, but other workers onto the site. And I think that's a vital and very important way to go forward. In terms of that, this new section, this is the duty to consult with other duty holders, clause 27. And I think this is a really important clause because if you think about any work site you're on, especially in the Canterbury rebuild, how many PCBUs are there at one stage? You know, you go past a building site and there's builders and electricians and plumbers and everybody there. Well, who's consulting with who? And who's running that process of consultation? And you might say, well, each to their own, we're all own our own PCBUs. This Act says no, you actually must consult with each other on that site. And how you do that practically is going to be something you have to develop yourself. So it's a very important obligation, I think you'll need to understand. You've got to do it when it's reasonably practicable. You've got to do it in a way which you cooperate with others. And lastly, you've got to ensure that you coordinate your activities on the site. And again, if you don't, you're subject to some significant penalties. I mean, that's what you'll find about this Act as you go through. You've got the 3 sections of major penalties, but if you actually to take out all the other penalty sections, there are a mass amount. And the government has actually just introduced some new regulations dealing with offences and penalties under the Act as well. So, yeah, there's just a huge number to become aware of. Number 8, PPE is worn at all times, or everybody, no exception. You know, from an employment perspective, we have a number of cases where employers say, but I told this person to wear their PPE and they're just not doing it. You know, the glasses are fogging up, or I don't like a hard hat on my head, or whatever. That is not enough, and that is not you know, going to be working under the new Act, because you must ensure that all people wear PPE at all times. And on top of that, you can't charge them for it. You can't require them to bring it themselves. So firstly, a PPE is actually defined as plant under the new Act. So it's a definition there which says plant includes PPE. There's also a section in there which says you cannot levy workers for a PPE. So you can't ask them to bring their own stuff along, you can't give them allowance for it, you must provide and make sure that it's appropriate PPE. 9, impairment. This is an interesting one. I'm interested to hear the Australian experience, but what we think is going to happen is that this will be an area where there should be a lot of activity, I think, from Worksafe in terms of this issue of impairment. And you know, Graham was just talking before about the fatigue work that your charter committee are doing, and I know there was a fatigue workshop sometime last year talking just about fatigue. That comes under the section here, hazard. You know, while it's a risk-based act, you know, risks are reliant upon hazards, and hazard is defined, and it's defined to include fatigue, so mental fatigue and physical fatigue. It also includes drugs and alcohol and you know, traumatic shock and so on. Now, the physical fatigue is and mental fatigue are very important issues. The very first prosecution, private prosecution that was going to be pursued under the current Act related to fatigue. An individual who was driving very long distances to work, doing exceptional hours at work and then driving home. And one day he drove home and killed himself. The engineers union were looking to bring that as a private prosecution. It was going to be the first prosecution. That didn't proceed on the basis that there was some evidence that came out that he perhaps had been smoking marijuana, which wasn't going to be helpful to the case. So they didn't proceed on that, but the employer and engineers union got together and said fatigue is a real issue, and they brought that to the fore. But the first case that did go ahead from a private prosecution basis was a meatworks, where an employee turned up to work high as a kite, and that was the evidence. He was absolutely stoned, undertook some work using a method which was incorrect and injured himself. And now the fact that he was high as a kite was irrelevant. Worksafe didn't prosecute, but a private prosecution pursued, and they were successful. So it just shows the importance of physical and mental fatigue. There is the one case which Department of Labour took a number of years ago involving an engineers company up in Blenheim, where an employee was so stressed because of work she had to leave. They were prosecuted for a stress-related illness. So there has been one example. We thought that case might open the floodgates, but it hasn't. I think under the new Act, though, this element of health and safety will become quite a bit more important. Because if you actually look at the definition of the Act, it's the Health and Safety in the Employment Act. And people forget about the health aspect. Wellbeing is massive at the moment. Drugs and alcohol policies are very important at the moment. Fatigue is becoming a really big issue, especially in Canterbury, but also around New Zealand. So I think watch out for this section and think about those soft elements of safety, the health elements. You know, do I have a wellbeing policy at work? How do I comply with my charter commitments by ensuring that people aren't too fatigued? And lastly, that moves us beautifully on to health and wellbeing. So I've actually gone back to the beginning of the Act to talk about the last commitment. So the last commitment, Commitment 10, is about actively promoting the health, safety and wellbeing of our people. And if you actually look at the purpose of the legislation, it is about securing health and safety of workers. Securing is a very high level to achieve, and it goes on to say that we must provide the highest level of protection. Again, establishing that really high level you must achieve from a health and safety perspective. So for me, health, safety and wellbeing is going to be that sort of sleeping giant that I think a lot of employers need to come to grips with in terms of the soft side of health and safety. There we go. So before I leave, I'll give you an example of how health and safety should not be done from a practical perspective, and it comes from Australia. So, I'm sorry. But I recently went to Melbourne, and Australia's had this Act in since 2011, so they're 3 years advanced on us, or so you'd think. So we went to Melbourne, and friends of ours stayed in this beautiful apartment block, and it was a magnificent apartment block, had this incredible gym. And so they went to the reception area and said, look, we want to use the gym. And she said, yep, that's not a problem, but given our health and safety laws, you have to be inducted to use the gym. And they said, yes, no problem, I'll be inducted. The person who inducts comes on Saturdays. They were staying there Monday to Friday. So if I leave you with anything, health and safety is about being practical, about ensuring that what you do can actually work. Because you can have all the nicest policies in the world, but if they don't actually work in practice, Worksafe are going to come and visit you, and it won't end up very well. Thank you.